Thank you very much. I'd like to thank Bloomberg for putting on this great event. Like many of you, I've been to a lot of conferences over the years, but this is a clear standout just in terms of the caliber of attendees, the speakers, really even the venue and the food. I think I'm still thinking about the cheesecake from lunch, which was awesome. I'd also like to thank the speakers coming together today to really talk about in-house counsel's expectations around changing data privacy and security regulations, which really are happening at warp speed. I'm really eager to hear what the panelists have to say from Snowden to the Facebook ruling to Safe Harbor, Privacy Shield, to the daily data breach of the day. This stuff really is front page news almost every single day. Obviously, it's a global problem that in some ways is becoming fractured regionally by just this fabric of data protection and privacy laws, which is really driving up the cost. I think it was David Levine in an earlier session who talked about it in many ways being a sunk cost that's really increasing the expense load for law firms and service providers that can sometimes be at odds with the expectation of efficiencies in the market and lower rates. And it's really that environment that's making it critical for everyone to know what's happening with data when it moves on to a third party, whether it's a service provider, a regulator, or another entity. This topic is really important to Epic. We are engaged by clients around the world to work on some of the most high-profile pieces of litigation and investigations, and it's really matters that require bricks and mortar data centers and regional teams in many ways to comply with privacy laws that require data to be collected, harvested, reviewed, and often produced in country. We also are positioned as one of the leading providers of data breach incident response services, providing notification in the wake of an incident, call center services, and credit monitoring. Brooks Taney, who heads up that practice, is also here with us today. So let's get at it and hear from our panelists. I'd like to welcome to the stage Alex Butler. Alex is Vice President and General Manager of IP, Privacy and Data Security, Tech and Telecom for Bloomberg BNA.
Well, thank you for the introduction. It's going to be an interesting panel. It's actually probably the easiest panel to moderate, given we have giants in the field of privacy and people who have immense perspectives from many years in very important roles in their respective corporations, both domestically and internationally. Thank you for the introduction as well. I think that one thing that certainly has struck me over the course of the day, there's a conversation around the change of the legal profession and industry. Privacy and data security is certainly one of those fields where that is running rampant. And it's also topical. I think probably a majority of you have either addressed or are fearing addressing one of these issues, or certainly been engaged in conversations around how your companies and firms will address that. So with that, I thought we'd start with just maybe a view from Lisa Soto from Huntington Williams about how has this practice changed over the last 10 to 15 years, much less even the last 2 or 3?
Dramatically. Really dramatically. So I started doing this in 1999, and most of us that were all of us in it from the early days did something else before. We came to this from somewhere else, and actually both Harriet and I came to it from the environmental world, which sounds really different from privacy and cybersecurity, but in fact there are so many parallels. And the way I came to it was that I had expressed interest in the internet, and the partner who was the head of our technology group at the time said, hey, you're a complex regulatory lawyer. There's this thing, privacy. I abhor regulatory work. You take it. So there it was. So since then, we saw GLB come into existence, ground leash flyleaf for the financial sector, HIPAA for the healthcare sector, and then a panoply of other privacy laws in the United States. And of course, very important was in 1995, the European Data Protection Directive came into being. But it took years after that for the member states to encode that into law. So there were years of sort of uncertainty about what this was going to be. And there were very few of us practicing in this area. And then everything exploded in 2005, really, with the first data breach of national note. That was ChoicePoint. And then following on the heels of that, TJX. And so then cyber and privacy both sort of grew in parallel after that, and really were very, very much linked. You do a little Venn diagram. And then 2 or 3 years ago, it exploded yet again with the Target breach. Again, a line in the sand there. Because with Target, we saw the first CEO, at least in part, resign as a result of a cybersecurity incident, and 7 of 10 board members were threatened with ouster. That was a sea change. And then the panoply of other very well-covered media events, cyber events, occurred after that. So also in parallel with a very dramatic change in Europe, where the directive that's been in place since '95 is being replaced by the General Data Protection Regulation, and will be replaced in 2 years, which is probably the biggest event in our lifetime, working lifetime, in the data protection arena. So it's been, boy, it's just been an explosion from that first moment to the present.
Yeah.
So in parallel, Lisa and I have had a career somewhat in parallel and together for the last 20 years. In parallel, about 20 years ago, in 1996, I was working at IBM in a in-house policy position in environmental policy and energy. And I had broadened my portfolio of issues. And one day I get a message that said that the CEO and chairman of the IBM Corporation wanted somebody to look at this issue called privacy, because we knew at a senior level it was going to be a big issue, privacy and data security, big issue for the world going forward because of the internet and the emergence of the web as a medium for e-commerce, for commerce. And so we're looking at the issue as a policy issue, as a what should an organization do, what kind of policies and procedures should a company have? And then secondly, asking, well, what kind of laws should be in effect, and how do we go out and shape them, and what do we do to plan for the scenario that is almost inevitable, that there would be more regulation of both privacy and data security. At the same time, less publicly perhaps, but also understood, was the fact that digitization and connectivity would lead to the injection of some sort of risk in a more digital infrastructure. And even then, it was clear that there needed to be some attention paid to infrastructure security, but it wasn't a public policy issue. It wasn't really a public issue. It was sort of understood that that was something to think about. But fast forward now, I spent almost 20 years at IBM. I was chief privacy officer. That's a role that now a lot of organizations have privacy officers. Actually, the new European General Data Protection Regulation mandates the appointment of such people in organizations so that there would be some accountability, just like a compliance officer, over this issue. But I was the first one, I think. And folks, I think, say, and you can research it, I think, that in the Fortune 1000, when I was appointed in the year 2000, that was the first appointment by a company of that role. So I spent 12 years at IBM then building a privacy function, but also, as Lisa said, in 2005 or so, really became the first breach notification laws that required some attention from a legal perspective and a compliance perspective, risk management perspective to data security. At the same time, the other piece here is really being driven not so much by regulation yet, although it will come more so, but by the reality that there are increasing threats. And the more we digitize and connect to one another, now that we are in a world where more than just data is at issue, it's the operations of digital infrastructures, and I assume we'll talk a little bit about that, and digitized products, came the issue of cybersecurity, this word cybersecurity, which we really didn't talk about in our field maybe 5 years ago, and now it's all over the place. And every survey of directors and general counsel validates that it's a top issue, a top risk issue. And the question I've been engrossed with, I think, for my career has been, what's the role of the lawyer in these areas? For privacy, it's a little obvious, right? Because it's a lot about law, it's a lot about policy. What do you do about the data? How do you construct rules, whether they're imposed on you by regulation or by law or by your own industry efforts or your own company efforts? But in security, it was thought to be more about technology. And you know what? It actually is not. It's about processes, procedures, policy choices you make, and also all of the legal issues that are attendant with managing the risk of this kind. So it actually, when you try to prevent breaches, you kick out legal issues. When you want to look at something that's happened or potentially happened, you kick out legal issues. And unfortunately, if something does happen, there are significant legal issues. And it's not just about, as we've discovered, data breaches. It's about something might be compromised, and therefore you may have an attendant set of other kinds of legal issues. So that's really what I've seen happen in the practice of law from an in-house perspective, and now for the last 4 years at a law firm, where I'm maybe the more rare breed of an in-house person who's gone to a law firm. I'm a partner at Hogan Lovells, and I lead our cybersecurity practice. And in that last almost 4 years, came with the notion that, yes, there is a legal practice here. And lo and behold, there is. There's lots of work for lawyers to do, working with now an increasing number of companies who are appointing in-house folks to look at this issue, to look at it in concert with privacy frequently, and almost as frequently to look at it in parallel, maybe separately from privacy. It just depends. And both are interesting and really important relationships to have when you're outside counsel, is to understand what the scope of the client's work is and how you can help them.
Maybe Bradley Gate and Dr. Wolf from GE and Ford, you have general counsel responsibilities. So you're coming at this from a very different perspective than the specialists in the field. How have you seen your organizations over the last 5-10 years shift in their approach to these issues?
You go ahead.
So for us, it really has been, I think, just to pick up on what Harriet was talking about, this shift from thinking about cybersecurity is a technology, IT, sort of more hardware issue to deal with on the prevention and detection side. But I think more of a realization that it really is more of a legal issue and how to wrestle with it. And also, how to help senior management and the board recognize the risk here and how to deal with those risks. And there hasn't been a lot of deep thinking about this, and so it's been difficult to sort of find a port of call to find other experts that have spent a lot of time thinking about it. And one of the things that we've tried to do is think about cybersecurity risk in the context of the sentencing guidelines. And so on our core compliance processes, of course, we try to map to the sentencing guidelines to think about the risk and how we're managing the risk. And we've done that now with cybersecurity as well. And so using outside experts to sort of look at a risk assessment of the hardware side of it, the IT technology side of it, how do we score there, where are the gaps, and then trying to map that against the sentencing guidelines is a way to provide some assessment of how well we may or may not be doing. The more challenging piece of this has been then, how do you then translate that into helping the audit committee and the board understand what sort of questions they ought to be asking and how they should be thinking about this risk. And over that same period of time, what we've seen now is more robust inside the boardroom reporting on these issues, both at the audit committee level and the full board level.
Great. I guess what I would add is for companies like GE and Ford, and it's something that outside counsel probably don't have as much of a line of sight to, you think about enterprise risk, which is sort of where the privacy issue arose, and it's really the enterprise systems and the software and the servers that are within the company. And that has a level of complexity with it, but it's all kind of one thing and one risk, and you can manage it because it's yours. Where this is now evolving to, particularly for industrial companies like Ford and GE, is to product cyber. And the problem with that is it's multiple different kinds of systems in totally different environments. So you take your product, many of them, and you put them in your customer's site. So that's 2 levels of complexity. And then you figure out, okay, what's going to happen if they get breached? And it's not, data is a big deal, but it's a much bigger deal on the industrial side if the industrial equipment is impacted by this. And so it's a whole nother layer of risk. And what it also starts to suggest is a much broader conversation. To the point Bradley was making, it's not just IT, it's not just legal. It's HR, it's finance, it's communications, it's sales, it's government relations. So when you're working with an in-house legal team, you've got to think much more broadly than just, hey, I got to make sure I'm connecting them with lawyers. You've got a whole broad, it's probably one of the most cross-functional issues I work in at GE is this stuff. And it's really hard because there's so many different levels of understanding of it. The IT guys, they really get the IT aspect of it, but there's a whole lot of other stuff that they're just not up to speed on. And the opposite is absolutely true. Trying to get the communications folks who are very smart, but they don't know this world, to get them up to a level where they can actually talk intelligently and quickly, right? If you got a breach, you've got to respond within hours, and they've got to understand what they're talking about, and they don't, because it's just really complicated. And the lingo, there's just so much lingo in this space, it's really tricky.
Recently, Bloomberg and the International Association of Privacy Professionals, known as IAPP, completed a survey and was looking at this evolution of the practice and some of the challenges that both firms and corporations had. So about 350 or so senior inside counsel officers. One of the big challenges they were looking at was just how to stay abreast of all the changes with regulations, laws, different enforcement agencies getting into this game very rapidly. How do you do that as a firm and then as a corporation?
My lord, it is hard, I will tell you. Again, when we started in this area, there was nothing. When that first head of my technology practice sent me what he had, which was the compendium of everything in the United States, it was literally this big. So I read it, an hour, I was the expert. Now we have a panoply of laws in the United States, literally hundreds of them at the federal and state level. We have this new regime coming in Europe that is an extraordinarily stringent regime. And then beyond that, in the last 5 or 6 or 7 years, we have now new laws in the Philippines, in Hong Kong, an amendment, in Taiwan, an amendment, in Mexico, in Uruguay, Colombia, Peru. So you name it, there are data protection laws in really very, very many countries now. So we're keeping up as best we can. It is a 24/7 endeavor. We're trying to read. We're reading folks like BNA every morning, which is
We
really
appreciate
helpful.
that.
Truly, we have to gather as much literature as we can, and of course, there aren't the kinds of resources there are in established areas like SEC law or tax law. So we're grasping at straws much of the time, and there are lots of blogs. So what is the new media? It's blogs that are going up like that and helping us to keep up on what's going on. Plus, it is absolutely critical to have a global team. We can't operate in this data protection environment without a global team, because data, like water, is not constrained by state boundaries or by country boundaries. Data is global. It moves. It sits in 52 different jurisdictions all at the same time with 52 different rules applicable to the very same data set. And we need to understand all of those rules.
Yeah.
If
Go ahead.
If ever there was an argument for a team or a global footprint, this is it. And I know the IAPP study, which I think is very good, Bloomberg IAPP study on the need for and the growth of the privacy legal and data security legal services, it makes the point as well about the you can have specialization, but one specialist is not going to be enough to keep up. So having a team, whether you have it internally, most companies do not have the resources internally, plus some external resources is important. And the other piece here that's, I think, worth noting is the fact that there's a lot of lore, there's a lot of industry standard, there's a lot of judgment as to what really is what a company will be held accountable for and what is reasonable. Mm-hmm. And therefore, you ought to have a view of what the different laws are around data privacy, but in addition, in the security space, it's just as important to be aware of payment card industry data security standard or ISO 27001 or what the NIST framework looks like for your sector in order to really understand and advise your board and your senior management what good enough looks like. And you probably have a view on that, I would think.
Yeah, absolutely. But in this question of, so we do the same sort of scanning on a global basis, and we have the benefit of a structure in place that is really our primary risk management tool. We call the Creating Value Roadmap process, which has the leadership team together every Thursday. That's where I was this morning before this. But coming together, and a big component of that is also reviewing the business, but also a scan of the environment. So what's going on in the business environment with the economy, what's going on with our business around the world, and then for the legal team, what's going on with the legal environment. And so we have those inputs every week and talk about them every week. And they come from the law firms, BNA, other scans that we do. The big challenge is, after you have all that, we ask the question, what's the so what to Ford? And there's the challenge. Now you have all these inputs, and now trying to figure out, with really a lot of the opportunities ahead of us, with data analytics, how do you take disparate data from around the world, compile it in one place, and really try to provide business opportunity through that, and still comply. And so that is the challenge, and really getting our law firm partners and our in-house privacy people to understand how to sort of calibrate that risk, because getting it 100% isn't going to allow us to achieve the business objectives necessarily. So how do you balance that risk and get the legal team, senior management, and the board comfortable with it is the big challenge after you've scanned and gathered that information.
Maybe to keep the conversation moving forward, Buck, when you're looking at what work you keep inside GE and what work you're bringing outside counsel in to help you in these areas, what goes through your mind when you're making that calculation?
So let me bridge between the two things. So one of the areas that has grown a lot in the last 5 years is the industrial internet, right? So you've got, let's say, 7 billion people in the world. By 2020, there will be 50 billion devices attached to the internet, right? So that's going to dwarf the consumer internet. And that means there's going to be all sorts of data that has to flow. But the whole benefit there, the efficiency gain in that context, is the free flow of data. Because if you want a device to work better, you've got to have inputs from a lot of different versions of that device to see how it can be most efficiently operated. And that means free flow of data globally. So if you've got a device in China, a device in France, a device in the United States, you want that data aggregated to review it. The regulatory dynamic is moving in exactly the opposite direction.
That's right.
Right? There's data localization laws that are being considered in Russia, China, Europe, Brazil, everywhere. And industrial companies that want to benefit, and more importantly, consumers that will benefit from the efficiencies from the industrial internet, are challenged by that kind of regulatory environment. So then the question is, what do you do? How do you decide to deal with those kinds of regulations? Well, going back to the prior point about the many different types of regulations, you've got to pick a mark where you say, look, anything below this line, we're just going to comply with everything. We're not going to try to comply with each law separately. We're just going to assume the worst, most difficult standard, and we're just going to comply with it. And then there'll be stuff in particular industries like healthcare where we'll have a special place where we'll put that data. But the rest of it is just going to be in a place that complies with every law up to a certain level. That's just the only efficient way to do it. In that way, if new laws come in, you could say, well, is it above the line or below the line? If it's below the line, we're already complying with that, just put it on the list. If it's above the line, then you may have to do something different. And getting that information globally can be very challenging. And that's where the law firms come in. And also, though, we are lucky at our scale to have a global legal team and global law firms that work with us locally. So we've got a lot of different inputs. And on the data localization piece of this goes back to a discussion earlier today. That's where you say, you have the K&L Gates response, which is change the law. You got to go into those countries and say, look, you're going to be better off if we can share your data. And this is not personal data. This is, a gas turbine talking to another gas turbine. There's no privacy issue there. We don't need to localize that data. Now, they may disagree, but there's an opportunity to have a conversation with the governments in these countries to say, let's look at this in a little more sophisticated way. One of the things that we're seeing, and we're using our law firm friends a lot on this, is that there is a conflation of the consumer internet and the industrial internet. People just think of it as one thing. And the Internet of Things is being combined. So wearables are considered to be the same as data coming off of an industrial device. It's not the same thing. So we've got to get out there and educate lawmakers so they understand what they're dealing with. There could be a little more subtlety in terms of how they do this. I'm not sure I answered your question, Alex, but that's how we think about it. It's really more of a problem and a challenge to us from a business perspective than it is this is a legal issue.
Now, maybe shifting the topic a little bit, and you were talking about the different types of data and how different, you look at your business differently than, say, maybe a Fitbit or an Uber might. One of the conversations, and it was in the description for the panel, was around this issue of law firms actually having data as well and sensitive data. So maybe, Harriet, you have a thought on, or at least a thought on, you're the vendor and you have, whether real or not, you're a target.
A law firm is a business. It's a service provider, professional services firm, and you're right. I mean, we as lawyers have ethical obligations to maintain confidentiality. There have been recent changes over the last 5 years to, in the United States, the ethical rules to talk more about our ethical obligation to also understand the role and the implication of using certain technologies and to assess and address those kinds of issues. That's very much in keeping with what every other type of service provider is expected to do these days by your clients and your customers, which is to have a reasonable security program in place and to have a back and forth about security. And so it's not a surprise at all that law firms are one of those kinds of organizations that have to step up to security. And it's an important and imperative, it's a cost of doing business that I think we all understand. And you know, there are practices, and I think we'd be interested to hear others talk about it, but there are, you know, we advise regularly our clients on how to look at vendors, how to look at vendor risk, and how to manage that risk. And there are steps to take. They range from asking the questions, asking to have conversations. For higher risk vendors, when you actually share information that is or allow interconnections to occur between your organization and another organization that involve connectivity. Typically, a law firm isn't that interconnected with a client, but there are other settings in which things like that happen, is to mandate certain standards, is to have a back and forth. Those are good practices that are happening in our industry in addition to others. No surprise there.
Lisa?
Yeah, you know, just as Harriet said, we work with companies that are fortresses. They have systems, they have firewalls, they have segmentation that is truly extraordinary. But we have, as lawyers, sometimes authorized access to their systems. So to the extent they have a fortress and the bridge is down over that alligator-filled moat, we walk right across and we walk right into their environment. So to the extent our environments have been penetrated by attackers, their environments are then penetrated by attackers. So just like any other small or medium-sized business, we should be held to the same standard, and of course we haven't been, as made very plain by events in recent weeks. But the standard is do due diligence on a vendor to make sure they have the ability to protect data the way that we expect them to protect data. Second is have appropriate contractual provisions in place, and the third is ongoing monitoring. You can't, you don't, it's not your get out of jail free card just to do your initial due diligence and then contractual provisions. And then it's that troika of activities that is absolutely expected by the FTC and other regulators, and they will ask, what due diligence did you do? What contractual provisions did you have in place? What ongoing monitoring did you do if there was a breach? So we have to show that there's evidence of all of that. There's a very good document that the FTC has put out recently called Start with Security. So I would commend that to law firms as an initial foray. And we have been really subjected to extraordinary levels of audits now that we had absolutely never seen in the past. So we had a financial institution come and sit on site a couple of weeks ago. And they insisted on a clean desk policy, and boy, we shaped up quick. So we are experiencing truly the same stringent techniques that we have imposed on behalf of our clients on other vendors, and it's certainly eye-opening.
Yeah. Bradley, from the buyer's perspective of hearing this from your vendors or your outside counsels, you know, how is this changing at Ford and then Buck at GE?
Yeah, it's really interesting. And so when this first came to light, it was sort of course. But I think as we stepped back and thought about it, there's this continuum of kind of how we might have been thinking about the risk here. And that is, if it was in-house and you were just sort of having a relationship with a service provider, you thought differently about the security risk. But if you actually outsource something, like you would on the financial services side, like payroll, accounting, tax work, you did take a very different approach with that. And you did have contractual arrangements that made sure that the vendors were ISO certified, that they had an obligation to notify you if there were a breach, that they had protocols in place for how they would access their systems remotely. And we actually had rights to send our audit team in to audit on a regular basis to make sure that they were adhering to those contractual arrangements. And so I think for us, for the larger firms that we work with, like Hogan, you know, those same sort of contractual arrangements will probably be put in place. And then we're thinking through sort of at the smaller firm end, what's the right answer there? And is it just that you then maybe allow them to have access to our environment where we know the data is protected, and that's where all the documents are stored. So still trying to sort through it, but there'll probably be at least two answers, one for the real small firms that help us locally and the larger law firms that can comply with these requirements.
Yeah. And Buck, your perspective?
Yeah, the only thing I would add is the most important thing is if there's a breach, the most important thing is to come and tell the client immediately. Don't have Ford read about it in the news, right? Be honest and be very proactive and say, here's what we're going to do to fix it. This is what happened. There's a tendency to say, oh my God, we've got to figure out what happened. We've got to fix it all before we go and tell. But the cat's out of the bag at that point. So it's really important to be upfront about it when it's happened. And we've had it. I think every company's had one of their law firms breached.
So maybe returning back to the growth and changes in the practice, we've done some independent research looking at just the size of privacy or cybersecurity. It's different titles at different firms, but you're seeing year-over-year growth, double digits in many cases, 40, 50%, and sometimes that's real, and sometimes there's some crossover with other practice areas. This was a small area of law just a few years ago. So how are you facing the supply and demand issue as a provider of services, Lisa?
Demand very, very much outweighs supply. In 10 years, we're going to have a different story. So we are all training folks in this area, but right now there are many, many, many first-year associates who are very interested in the area but don't have an iota of knowledge other than perhaps having taken one law school class. And as Harriet said, I think very appropriately, this area is full of lore. There is so much nuance. It's culturally based. You have to understand all of that. You cannot, in this area, probably in any area, but we can tell you for sure in this area, you cannot just open a book and understand what to do. There's a whole culture around both privacy rules and interpretation of privacy rules, and certainly security as well. In the United States, there are 47 state data breach notification laws, plus Guam, U.S. Virgin Islands, Puerto Rico, and D.C., so 51. And yes, you can read any one of those, but how do you manage a breach that implicates all of those laws? That's more art than science. And so we really don't, at this point, have sufficient numbers of lawyers who can do that. But we're working very hard at training, and I think the situation will change in about a decade.
Harriet, at your firm?
So a couple of points, I guess. One is that there's a great demand. There's huge interest. I think a lot of the students coming out of law school are interested in this area. They think it's hot, which is kind of nice. So you get to pick the really great kids. It's wonderful. One point to make is that actually people with technical backgrounds and people who are technically trained have a lot to offer in these areas. And so putting a premium on attracting folks that have technical backgrounds, but also what we have found is, particularly with respect to security work, when we're investigating or helping a client address a breach, or trying to help a client assess where it stands vis-a-vis what a reasonable standard is for their organization, it really helps to have people who have technical chops and security experience. And so what we've done is, under a banner we called it solutions, our cybersecurity solutions. It was said, to heck with the practice areas, let's just cut across the entire law firm and figure out where people have knowledge and put them together and knit them together. And maybe it's partly it's my in-house kind of corporate attitude and experience in matrix organizations, but we've put it together. We've put together a cross-discipline team that we call a cybersecurity solutions team, and it's got litigators, investigators, et cetera, et cetera. It also has technical and risk managers. The former chief information security officer of the Marriott Corporation, Marriott International, is on our team. He's not a lawyer. And he and a group have formed a cyber unit, a business unit, that is actually locked into what we do for our clients. And it's a way we have found to be a way to expand our supply so we can meet demand in a way that makes sense to our clients. And so that's a little bit maybe on a new business model side of things, is how do we actually innovate around what our clients need in this time when everybody's looking for value in a different proposition, but in this area too. So we're not approaching it kind of as a traditional practice area. As Buck said, I've never seen, I've spent my career in this area. This thing cuts across every single possible part of a company. I have had questions from securities lawyers to product liability lawyers to aviation lawyers about cybersecurity, and I cannot possibly have a practice that is this narrow. It has to be across, and it's a wonderful way to practice. It's very energizing and interesting, and it's the future.
Now, Buck, by definition, you're general counsel for an R&D function. So that technical perspective, in addition to the legal, perhaps you could comment on how that plays out inside.
Yeah, and I think it seems kind of weird that I'm here from the Research Center GE, but the reason that it's my responsibility is because of the background in the technology, understanding what we're actually talking about. So what we've tried to do on the legal front is teach people to fish, because you've got to get people up to some minimum appreciation of the issue. There used to be a dynamic when I at least was in law school where you could joke, well, I don't know math, that's why I went to law school, or I don't understand science, that's why I went to law school. That joke's not funny anymore. If it ever was, it isn't now. And people have got to be serious about this stuff. So we have regular calls that I lead. We've gotten every business to at least assign one lawyer who owns this issue for that particular business, and we have multiple businesses like many big companies do. We meet regularly, and then they have to go out and spread the gospel, make people sensitive, get people educated on what's going on, what's new in the area, and just try to raise it up enough so that people can at least spot the issue and they know, who they should call on the bat phone when something happens. Because when you're running a distributed organization, that's really the only way you can do it. You can't possibly, particularly with the challenge of finding the talent in the space, go out and hire enough lawyers to actually own the issue across the whole place. It's impossible.
Yeah. Bradley, maybe you could look at this as well in terms of recruiting, and then maybe also add an international perspective, given the global nature of Ford's business.
Yeah, and I was going to pick up on this point too. So we do something very similar in terms of training people to do issue spotting. The challenge that we have is really then the deep expertise that we'd like to cultivate in-house and get people that are focused strategically on this issue. Because privacy isn't just, in cybersecurity, it just isn't a compliance issue. It can really be a competitive advantage if done right. And as you think about the Internet of Things, in our space, the future of mobility will require the sharing of information to really enhance the products and services that will ultimately be offered. And so having people on the team that are deep experts that can think strategically about this is going to be critical. And so right now, we're really reliant on US-based lawyers who have this expertise working closely with in-house lawyers. But that is the challenge that we have. And we really rely on outside law partners to really help us think about the strategy associated with what does our privacy policies look like. But in-house, the team is really doing things like the privacy impact assessments, the internal policies. But when it comes to really thinking through the strategy, we're heavily reliant on outside partners.
Let me pick up on that for a minute, because it ties together a lot of things that Harriet and Lisa said as well. This started out as a risk practice area, because the environmental background and safety and all of that, it's not that anymore. No. This is an opportunity, and what you see now in big industrial companies is that the customer solicitations all require an expertise in cybersecurity. So you can't even be at the table anymore unless as a company you have this expertise. And it's a differentiator. If you're better at this than the other guy, then you're going to get the business. And so this is not the risk function, this is the sales function.
Yeah.
This is the guys writing the contracts. How do you manage the risk? How do you, what's the liability dynamic? It's a much broader play. And it's a good thing in the sense that once it starts making money for the company, you're getting a lot more interest in it, because risk tends to be underfunded. But it's a whole broader play. And then you got to be careful, because if a company goes out and oversells their cyber security chops, then they get in big trouble. And that's the FTC point. So you really got to balance those two things. It's interesting.
And it puts a big premium on really design thinking. And
Yep.
so privacy, cybersecurity just isn't a bolt-on at the end after you produce the product. But how do you get it integrated up front and in the product so you're compliant, but you haven't destroyed the value of the product or service you're trying to offer? So
I agree.
That's the challenge that we have.
All right. So we have just a few minutes left, so do want to leave some time for a couple audience questions. I'm sure if there's a microphone that's coming around the room or not. We have a question over here. Then maybe while the microphone's coming through, we can, very quickly, Harriet, we'll start with you. your 30-second forecast of where this all heads in the next few years.
In the next few years, I don't see any new major laws in the United States. Watch Europe. Watch the Europe implementation of the General Data Protection Regulation. In the next 2 years, the move up to it, very large penalties, a lot more substantive requirements. That's on the privacy side. On the cybersecurity side, whoever is working with organizations, inside organizations, prepare.
The question?
Yes, Peggy Miller from MWH Law Group. There's another trend that I'm wondering how you see it impacting the security area, which is openness. One example being that the Copyright Office has declared that software in automobiles needs to be available to the consumer. It cannot be secret and proprietary. It cannot be protected against encryption and such. The thought being that I should know what's in my car and I should be aware of that software. The interplay of intellectual property laws, which that used to be proprietary code that wasn't shown to the public, the use of open source software, which requires more public disclosure. Do you think that enhances or makes it more difficult for you to protect the assets of both your customers and your company?
It's all yours.
Automotive software is a topic, I hear.
That is a great question. And so for us, questions like that are really the challenges in front of us that are right on the horizon. And how do we deal with that and the other security issues associated with mobility? And we've got to sort through those answers.
You know, I think the Apple FBI issue was really classic on this. You know, how do we deal with the going dark issue? Is encryption a good thing or is it a bad thing?
Yeah.
Sometimes it's good, sometimes it's bad, and you know, very much depends on where you are on the political side of the fence. This is a nascent issue as a society. We have just begun to talk about these issues, and the real answer is we have no idea, and we'll work through it over time.
If I had to predict, there won't be a panel in a few years on cybersecurity because it'll be like a panel on the internet. It just will be what it is. It'll be ubiquitous. And it'll be just something that everyone considers.
All right. With that, we have to think of 1 minute left. So a question over, right?
Is there some insurance coverage for a cybersecurity breach?
It's a huge market.
There is, and it's right now, I just heard this statistic a couple of days ago. Cybersecurity insurance has only penetrated 30% of the market, but it's the biggest selling product by far now. So it's a huge product in the insurance space, and we have some clients that are insuring up to $100 million in cyber risk, and this is very, very, very costly insurance.
Any particular carriers that?
All the carriers.
Let's talk later.
They're all doing
Particularly for law firms, as law firms in particular, it is a worthwhile item to look at.
Bradley, maybe your forecast, and then I think we'll wrap up.
Well, I think it was this issue of the challenges we'll face with mobility, and a big watch out for us is the evolving laws in Europe.
Well, thank you everybody for joining the session, and a big hand of applause for our panel.